is some kind of a sweeping matter regarding the entire use of the oceans, and we've already mentioned all the different activities that we believe are protected by the language of the convention.
But they've already identified a land source of pollution and basically charged Great Britain with polluting the oceans. Is there any reason to think that they won't find something in the air 200 miles off of California and try to make some claim on the continent of the United States? I mean, obviously we're concerned with mission creep, and I know you can't answer that question, and my talk was more to express a concern than a question. They have no way to enforce anything that they do, so the whole premise is based on countries that abide by the law.
But when it comes to economic activity, which a lot of this deals with, whether it's seabed mining or continental shelf exploitation, if you don't have some kind of international recognition, it becomes a lot harder to find investors and companies that are going to be willing to take the kind of risks that are involved in exploitative economic activities in what I think are fairly characterized as usually quite hazardous and challenging conditions when you're getting out into the sea.
I know my time has expired. Thank you very much.
Mr. Chairman, if I could respond to the question raised by the Senator on certainty. I think there's some national security points here that are germane to this, if I could follow.
All right, Admiral Walsh, go ahead.
Yes, sir. Thank you.
I'd ask you to be fairly brief if you could. We're trying to get through the round here. But,
yes, sir.
Go ahead.
One of the challenges here, sir, with regard to legal certainty is customary international law. That's the practice here that states operate with. We don't have much experience with that here at home, and so it's hard to recognize when we see it. I can tell you from living in the neighborhood what it looks like. It's when a state starts doing something different. And in this particular case, since the 1975 Algiers Accord between Iran and Iraq, which had codified the border between the two countries, what that had done during the Iran-Iraq War at the termination of hostilities, Saddam made some arrangements that no one really knows or understands. And what has happened in place since the end of that war in 1990 is a custom, is a practice of who owns what water. These are waters in dispute. And we have measurably and seen demonstrated now changes to customary international law in Iran. You may remember that as the UK-15 who were picked up in Iraqi territorial waters. What we are witnessing over time is assertions, exaggerated assertions, illegal assertions by a country that is not party to the convention that is now migrating through course of habit and practice, intentionally moving the line into Iraqi territorial waters. And so for those of us who live here, this is hard to see. This is a huge issue for those who live in the region. The legal certainty that we ask for in this treaty is the codification of understanding what the territorial seas are, what the contiguous zone is, what the economic exclusion zone is. That's what we mean by legal certainty.
Okay, and Iran is a signatory.
No, sir, they're not.
Well, they're on the list.
Well, I've got the list here.
I don't think it's been ratified, but they're on the list.
Apparently, Iran has signed the treaty,
right,
but is not ratified,
and will not abide by it.